Rob Masson is the CEO of the DPO Centre. The DPO Centre is a provider of outsourced data protection officers and data protection consultants to a wide range of clients across the UK. And they also do representation services to lots of US and Asian organizations. As founder and CEO of the DPO Centre, Rob is actively driving innovation, transformation, and thought leadership in data protection and privacy. Supported by the DPO Centre's large team of privacy professionals, Rob advises on evolving data protection legislation and how issues like Brexit will affect the strategic direction of organizations around the world. So, Rob, great to have you with us, and over to you.
Thanks very much, Rob. Much appreciated. Just brought it in just under the wire there in terms of technology, but very pleased to be with you. Thanks very much. It's a pleasure to be part of the webinar and also for the DPO Centre to be one of the sponsors of today's event. I'm told if you double click on the slide share, it'll give you a slightly larger screen. So again, a slightly smaller me. I think that's probably more important. So my aim for this webinar is to help you understand some of the data protection related issues that are associated with Brexit and the steps that you're going to need to take over the coming months. We're going to cover the transition period and the period that we're currently in and the changes that you're going to need to expect to deal with. We're going to cover what's meant by the word adequacy and the implications for the UK becoming what's known as a third country. We'll cover some detail over data transfers along with some of the issues that you're likely to need to consider. And we'll finish off with a quick summary of the steps that you're going to need to take. Now, clearly, Brexit's a rather nebulous subject to cover in only 20 minutes. So if there's anything I don't cover, do please pose your questions as we go along, as hopefully I'll be able to answer some of them in the Q&A session towards the end. You can do that by using the chat tab in the top right-hand corner of your screen, and then hopefully one of my colleagues will sift through some of those and we'll take a look at those at the end. So let's deal with the transition period first. So the UK formally departed the EU at 11 p.m. on the 31st of January this year. That means that we're now in an 11-month transition period that's been set aside to take care of the final negotiations. There was an option for the UK to be able to extend this period for up to 2 years, but actually the UK government has now confirmed last week, in fact, that they won't be extending that period. Therefore, the transition period will automatically end. We don't need any act of government or anything like that again. So it'll automatically end at 11 p.m. UK time on the 31st of December this year. So whatever that is, just over 5 months' time. Now, up until that point, it is essentially business as usual. But if you transfer personal data to or from Europe, then there's still quite a lot to think about. But what the exact landscape looks like, up until after the 31st of December is still a little bit unclear. So there are some things that are not definitive yet, but I'm going to take you through as much as I can do that is. So in terms of how the laws are going to change, the expectation is that many of the EU laws will become UK laws. Or at least initially, at least. We've had about 230 laws introduced into the UK based upon EU obligations. One of these is obviously the EU GDPR, which currently at least has now become the UK GDPR. So as it stands, from a practical perspective, the UK GDPR is identical to the EU GDPR. We enacted the EU GDPR into UK law back in 2018, and that was via the Data Protection Act of 2018. But the DPA doesn't duplicate the text of the GDPR. It essentially just kind of references it. So the government will simply amend the Data Protection Act to reference the UK GDPR instead of the EU GDPR. So it's generalizing slightly, but that's essentially what's going to be happening. So fundamentally, until we hear otherwise, the GDPR is very much here to stay within the UK. So though, of course, from January 2021, if you process personal data on UK and EU residents, then you're going to have 2 times GDPR to comply with, being the EU and the UK versions. Now, what's likely is that based on government reviews and regulated decisions and case law, the 2 currently identical versions will diverge over time. So you're going to need to keep up to date with any changes that occur in both of these laws, as changes in one won't necessarily apply directly to the other. So, like any other country outside of the EU, from the perspective of GDPR, the UK will become what's called a third country when the transition ends. This means that personal data is no longer permitted to flow freely between the EU and the UK as it does currently. We're going to need to add additional safeguards into the agreements that we have with the various people that we're exchanging personal data with. So this is, of course, unless the EU grants the UK what is known as an adequacy decision. So adequacy decisions are made by the European Commission. 12 other countries outside of the EU so far have been deemed to be adequate by the Commission. So the UK submitted an adequacy application in anticipation of us leaving the EU. And at the same time, the UK has stated that it considers the EU and the 12 other countries to be adequate. So we consider them adequate, they just don't consider us adequate yet. So the issue is not so much the transfers from the UK to the EU, it's more the transfers from the EU back into the UK. So adequacy decisions normally require about 18 months. That's been about the average. So that's how long the Commission is taking to make that decision. So, given we didn't start the process until after we left on the 31st of January, and apparently we are 13th in the queue of countries wanting an adequacy decision, it is by no means guaranteed that we'll receive a decision by the end of the transition period, the end of this year. And even then, it may not even be positive. So what this means is that in that situation, individual additional contractual safeguards are going to be needed to be implemented with each and every one of your suppliers and your partners and your vendors that you exchange personal data with. Now, this will most likely be in the form of what are called SCC, so standard contractual clauses. And these will need to be inserted verbatim, so no changes allowed, as additions and addendums to your existing contracts that you have with these various suppliers and partners. Now, so that the mechanism of doing it is not necessarily complex to implement, but of course it's extremely time consuming. And in the case of some contracts, which are difficult to renegotiate or to amend in any way, certainly going to be problematic. So, in terms of timescale, it's certainly something that is worth considering now. So another potential stumbling block that we've got for organisations that process data across multiple EU member states will be the loss of the mechanism known as the one-stop shop. So each member state across the EU has their own independent regulator or supervisory authority. Those two phrases are used kind of interchangeably. In the UK, ours is, of course, the Information Commissioner's Office, or the ICO. And these regulators all agreed quite early on in the process to introduce a mechanism called the one-stop shop. And the one-stop shop is there to simplify the situation for organisations that have their main EU establishment in a single member state, so such as the UK. But they process data across multiple member states. They have a presence in multiple member states. Now, the one-stop shop means that in the case of something like a breach, you need only deal with that single nominated lead authority and not each authority from every member state where the data subjects, the affected data subjects reside. So as it's currently understood, after the 31st of December, the UK ICO will no longer participate in that one-stop shop mechanism. So if your organisation is established in the UK and Europe, and you're currently using the UK ICO as your lead supervisory authority, you're going to need to decide which of your other offices across Europe is the one that is making the processing decisions and nominate the supervisory authority from that member state as your lead authority. And the processing decisions is quite an important thing. I don't really have time to go into it, particularly today, but they have to actually make decisions about that processing in order for them to be a valid candidate for to be nominated under the one-stop shop. And you'll need to update your privacy policy to reflect that decision. So if no single main establishment can be identified, then of course it means you can't take advantage of the one-stop shop. And so what that means in reality is that in the case of that breach, you may need to deal with multiple EU supervisory authorities as well as the UK ICO separately, which potentially means it leads to enforcement action from multiple supervisory authorities, not just the one. So the 12 current countries that are currently deemed adequate by the EU does not include the United States. So the United States data laws are not considered to be essentially equivalent, which is the kind of the grading used by the EU to define whether something is adequate. But of course, most of the world's data, personal data especially, is processed by US corporations. So if you think, Google, Microsoft, Facebook, Oracle, Dropbox, all of these US corporations are the ones processing all of our data. So we couldn't just, the EU couldn't just stop transferring or put a block on it. So what they did is they created the Privacy Shield framework, and it's a code of conduct that provides a mechanism under which US organizations can self-certify and agree to abide by the 23 principles that obligate that member to comply with the EU's data protection requirements. So it's not a country decision, it's an individual organization's arrangement. So in terms of the UK and the US data transfers, it is still business as usual until the 31st of December. But after that date, the UK will continue to recognise the validity of Privacy Shield. So UK to US transfers is still recognised as being valid. However, in order for it to continue to apply, you are going to need to confirm with that Privacy Shield member that you're exchanging personal data with, or they have access to data, that they have amended their privacy policy to state that the principles of the Privacy Shield have been extended to include data received from the UK. And so it's a relatively straightforward thing to do, but it is something that needs to be done as part of your Brexit preparations. And then another thing that a couple of organisations have been caught out on is confirming that that they've renewed their annual membership, because a couple of organisations didn't do it, and of course they were it caused problems later down the line. So so let's deal with UK representation. So Article 27 of the GDPR details when organisations need to appoint what's called a representative. So it's required by organisations that are based outside of the European Economic Area, who do not have a physical presence inside the EEA, but they are offering goods or services, or they're monitoring the behaviour of EU residents. Now, the EEA is the remaining 27 member states, plus Iceland, Norway, and Liechtenstein. So the purpose of a representative, amongst other things, is to be the local point of contact for data subjects and regulators, meaning that those people in the organisation don't need to be so concerned with kind of time zone issues and language issues and things like that. So a representative is there to be that contact point. So what this means is that many UK-based organisations will be required to appoint an EU representative from the 1st of January 21. So this requirement is also, it's unaffected by any adequacy decision. So whether it's a yes, a no, or a partial, a representative is going to be required irrespective of that eventual decision. So your representative must be established in a member state relevant to the data processed. So if your data subjects are spread across all or many of the member states, then your representative can be established in any of those member states. However, if you process data on, say, only Spanish data subjects, then your rep will need to be established within Spain. And then because from the 1st of January, we will have both the EU and the UK GDPR, it means that non-UK organisations, including those in the EU who are not established in the UK, will need to appoint a UK rep under Article 27 of the UK GDPR. And that further means that US organisations are going to, for example, I mean, anybody outside of the UK and the EEA are going to need to appoint 2 representatives. So one under EU GDPR in the EU and the other under UK GDPR in the UK. So let's have maybe a quick summary of the steps leading up. The first step to answering most of the questions raised within what I've been talking about today is to map your data flows. So understand your data transfers and the issues you'll be required to address. If in the absence of an adequacy decision, if you're transferring from the EU, ascertain the additional controls that are going to be required. Now, these are most likely going to be those SCCs that you're going to need to add to contracts and agreements. If you have establishments in other member states where processing decisions are being made, review who your new lead authority is going to be. If there's no obvious EU establishment, then you'll not be able to take advantage of the one-stop shop, meaning that in certain situations, you may need to respond to requests and be subject to penalties, actually, from multiple regulators. So if you don't have an establishment in any other member states, but you are processing data on EU residents, then confirm if you're going to need to have to appoint that EU representative. And if you have them, you're going to need to amend breach procedures and notification protocols to take into account the new jurisdictions and the requirements. Confirm that each of your US Privacy Shield certified organisations that have access to your personal data have extended their privacy policy, as I mentioned, to include the UK transfers, and also ensure that they've renewed their membership. And then finally, after Brexit, update your own privacy policies to reflect the fact that the UK is now a third country. So thank you very much. I hope you found that useful. I don't know if we've got a couple of spare minutes, hopefully. So maybe we can have a look at a couple of questions. Rob, I don't know if you're still around.
Hi, Rob. Thanks for that. Really great. Lots of food for thought there, and puts the latest political developments in a bit of context for us. A few questions coming in. I'll try to be quick. I had one about adequacy, actually. How is it that we can be considered adequate on the 31st of December, but not on the 1st of January?
Yeah, that one gets asked quite a lot, actually. So the answer is down to the Treaty of the European Union. I think it's Article 4, where it basically states that national security remains the sole responsibility of that member state. So there's lots of influencing factors on that adequacy decision, but much of it is down to a UK law that is called the Investigatory Powers Act of 2016. It was described rather unfavourably as the most extreme surveillance legislation ever passed in a democracy. So it's quite far-reaching. But what it means is that it's a law that is highly likely to fail the general and indiscriminate collection test that the European Commission will perform as part of its adequacy evaluations. Seeing as the Investigatory Powers Act is considered part of our national security, whilst we're in the EU, of course, it has to be ignored. But the day we come out, it has to be taken into account. And I think I suspect the UK is going to have to amend its laws in some way in order to get a positive adequacy decision.
Okay, thanks. And another one that's come in from one of our watchers about standard contractual clauses, SCCs. Are standard contractual clauses available, and do SCCs exist for processor to controller?
Controller relationships, yeah. No, they don't. Standard contractual clauses, you can just Google them and download them. They are they're an EU issued document. They still actually relate to the old 95 directive, but they're currently still valid and can be used. So you can just download them. But the important thing is that they get added into the documents verbatim. That's you cannot change a word of them. So they're easy to find, and you can just insert them. Now, I've got to get this right way round, but basically there are controller to controller and controller to processor SCCs, but there aren't processor back to controller SCCs, and that's the problem, is the fact that we've got this situation where the UK deems the EU adequate, so we're okay to transfer data to the EU, but we're not. The EU are not currently allowed to transfer it back without the controls being placed. So it's almost as if the EU organisations need. So if you've got a processor that's based in the EU, they need SCCs from processor back to controller. So there's a slight confusion there, but fundamentally, as long as you put the controller to processor SCCs in place, it effectively will deal with both sides of the arrangement, and therefore it does enable and does put the safeguard in place for the transfer back from the EU.
Thanks. One more very, very quickly. I'm saying from Ian Power. As an EU-based organisation with a UK subsidiary, would I then need to nominate a UK representative for data protection?
So if you are established in the UK, then no, you wouldn't, because its representation is mostly for organisations that are not based in the EU or the UK, but they are processing data on EU or UK residents. So now, if you have a subsidiaries and they are prepared to act as that representative, then you don't need to appoint one, because you effectively got a presence already that data subjects can contact and regulators can contact. The representation is predominantly taken up where you are not in the EU or the UK at all, and therefore you are required to have that legal representative established in that particular geographic location.
Rob, I'm afraid I'm going to have to cut you off there. It's been really interesting. I have to leave it there. Thanks very much, Rob. And
no problem at all.
Centre.
Great pleasure. Thanks very much.
Cheers.
Bye-bye.